Hey folks, welcome to today's Law of Self-Defense show, a very, very special show indeed, in part because I get to respond to a Law of Self-Defense member who questioned whether or not I might have made a mistake about the law, which is theoretically possible. I'm only human, like everybody else, but in this case, in fact, I did not make a mistake about the law. I'll explain all of that to you. Also, I'm here broadcasting from the CCW Safe headquarters in Oklahoma City, Oklahoma. They kindly let me use one of their conference rooms to do this. It does have to be a brief show. I have less than an hour to do this, get back to my hotel, and check out before I get in trouble with the hotel. So I'll be as concise as I can. If you're wondering what's behind me, by the way, that is a photograph from none other than Mike Darter. Mike Darter is one of the founders of CCW Safe. He takes beautiful pictures, generally of the outdoors and wildlife from all over the world. He travels all over the world to take these pictures, and he does make these photos available for sale. So I think they're gorgeous. I would encourage you to go to his website just to take a look at them. jmdarter.com is Mike's website for photography, JM Darter. But of course, he's also a founder of CCW Safe from where I'm broadcasting today. Had a nice meeting with Kent, the president of CCW Safe this morning, and had breakfast with Stan Campbell. Always nice to see my friends here at CCW Safe. So let me make sure we're streaming all the places we are supposed to be streaming before we dive into the substance of today's show. I know the audio is a little tinny, folks. I'm sorry, I forgot to bring my good microphone, so I'm just using the ear pods. That's just the way it happens when we're on the road sometimes, folks. That's the reality of traveling live streaming. Sometimes this is what happens. All right, so with that out of the way, let's go ahead and dive into the formal start of today's show. Here we go. So that's the question. What happens? What happens if you fire a shot in self-defense and you end up injuring or killing an innocent bystander? What does the law have to say about that? That's what we'll be discussing. Before I mention that, I should mention, of course, appropriately enough, given that I'm broadcasting from the CCW Safe headquarters, today's show is sponsored by none other than CCW Safe. Find out why CCW Safe is the only provider of self-defense coverage that I trust. I'm personally a member of CCW Safe. My wife, Emily, is personally a member. They're the only one of these organizations that I trust to have my back in reality should the worst happen. And of course, I do quite a bit of partnering with them. I think they're a great team here. I would encourage you to at least click over to that link, lawofselfdefense.com/trust, and learn why I hold CCW Safe in such high esteem. lawofselfdefense.com/trust. So, what brings us here today? Well, last Friday, I was doing a live stream from, I guess I was in Boerne, Texas, and a comment came up at the end of the show from Jared, Law of Self-Defense member Jared, who suggested that he'd come across a case out of Kansas, State v. Betts, that he felt, I'm going to put a link, that he felt perhaps was inconsistent or contrary to my representations about how the law would treat a situation in which someone fired a round in self-defense and unintentionally hit, injured, or killed an innocent bystander. That decision is State v. Betts. I'll put a link to it in the members version of the blog post version of today's show. But you can also find it there. lawofselfdefense.com/Betts will take you to that decision. So first, I'll share with you how I typically address this question, and then we'll examine whether Jared is correct in his perception that State v. Betts out of the Kansas Supreme Court takes a different view of this legal question than my own. So you're facing a deadly force threat. Some person's trying to kill you, cause you death or serious bodily injury. All the other elements of self-defense are presumably satisfied. You draw your carry pistol, you fire a shot, and the shot either misses or over penetrates, goes on. In any case, it strikes an innocent bystander, causing serious injury or death of that innocent bystander. How does the law treat you? What is the context of your legal liability, if any, for that injury or death of the innocent bystander? Well, what comes into play here is a legal doctrine called transferred intent. Transferred intent is usually applied in a negative context, meaning you have bad intent and that bad intent transfers over to an innocent victim. So the typical scenario would be, I decide I'm going to murder somebody. I'm going to murder Joe Smith. And I see Joe Smith on the street and I pull out my gun with zero legal justification, just a cold-blooded murder. I pull out my gun and I fire a shot at Joe Smith to murder him. And I miss, or the bullet overpenetrates, and it goes on to hit Mary Jones down the street, a perfectly innocent bystander. Now, I had no intent towards Mary Jones. I didn't even know she was there. I certainly didn't intend to harm or kill her. So what should be my legal liability towards Mary Jones? Well, what the law says is that the unlawful, murderous intent I had towards the intended victim, that murderous intent, that unlawful murderous intent, transfers over to Mary Jones. So although I'd only intended to kill only Joe Smith, under the doctrine of transferred intent, that murderous intent transfers over to Mary Jones, and I'm responsible for the murder of Mary Jones, just as if I had a murderous intent towards Mary Jones. The intent, the unlawful intent, transfers to the innocent bystander. Well, that legal doctrine also works in a positive sense. So if Joe Smith is not simply a target of my murderous intent, but he's trying to kill me, I'm an innocent victim of his unlawful deadly force attack. He's rushing at me with a raised machete. All the elements of self-defense are satisfied. So when I draw my pistol and fire that shot in this new hypothetical, I'm not firing the shot with murderous intent. I'm firing the shot with the justification of self-defense. And that shot either misses or overpenetrates and goes on to hit Mary Jones down the street, who I didn't even know was there. Well, the law of transferred intent would say that my good intent, my lawful intent, my justified intent in firing the shot at Joe Smith, that good intent transfers over to Mary Jones. And just as I would have no legal liability for the lawful shooting of Joe Smith, similarly, I would have no legal liability for the unintentional shooting of Mary Jones because my good lawful intent transfers over to her. Now, there's important conditions here. It has to be a lawful, justified use of force against Joe Smith. Meaning, in part, because one of the elements of self-defense is reasonableness, that my use of force has to be reasonable, to be lawful. It can't have been negligent. It can't have been unintentional or accidental. It can't have been reckless. Particularly if it's negligent or reckless, those are obviously not lawful self-defense because you can't have negligent self-defense or reckless self-defense. Negligence and reckless are inherently unreasonable states of mind. So if you're acting negligently or you're acting recklessly, by definition, you can't have been acting in lawful self-defense, in which case there is no good intent to transfer over to the unintended innocent bystander. So what might reckless conduct look like in a self-defense scenario? Well, imagine if Joe Smith is coming at you with the machete, but instead of making an aimed shot at him, and even aimed shots can miss, folks, or overpenetrate, but instead of making a responsible aimed shot at him, as aimed as the circumstances allow, you just cover your eyes and do a mag dump in his general direction. Well, if you do that, you know you're creating an unjustified risk of death or serious bodily injury to other people because some of those rounds are going to miss, for sure. You're not even making an effort to align them on target. You're just generally spraying the area. Well, I would characterize that as a reckless use of force and therefore not lawful self-defense. And if one of those spray and pray bullets goes on to hit an innocent bystander, you would not benefit from the doctrine of transferred intent to relieve you of legal liability for having killed or wounded that innocent bystander because you didn't have good intent. You only had a reckless intent when you fired the shots at your attacker. So if the use of force is reckless, it can have been lawful self-defense, and you don't have the protection of transferred intent if one of those rounds hits a bystander. Okay, that's how I always describe this. Your use of force has to be a reasonable use of force, inherently meaning not negligent, not reckless. So that brings us to State v. Betts. Where are you, State v. Betts? Here we go. And again, you can get there just by pointing your URL to lawofselfdefense.com/Betts. Will take you to this decision. I'm going to summarize it quickly, and then we'll read through the facts and what the Kansas Supreme Court has to say about this, and why, unlike the question posed on Friday, why it's not inconsistent with my explanation. In fact, let's go ahead and play the video clip from Friday, in which Law of Self-Defense member raises this question, and I promise to look into it. Here we go.
Jared, I want to address this. Jared, Law of Self-Defense member Jared says, "Hi, Andrew. I just read a case out of Kansas called State v. Betts. The Kansas Supreme Court decision is contrary to what you say about innocent bystanders getting hurt in an otherwise lawful self-defense case." Jared, I made a note of that. If I have time this weekend, I will take a look at that case, and if it seems to have substance to it, I'll do a show on it next week. But for any of you folks, I love these things being brought to my attention. If you feel there's a piece of law out there that's inconsistent with what I'm saying, I want to know about it, because I am more than amenable to changing my legal opinion if there's evidence, if there's a substantive reason to do that. It doesn't happen very often. But anytime you think that's the case, normally what happens is there's a nuance that's not apparent to the person who thinks there may be an error. But sometimes I do make an error, so it's always worth taking a look at.
And of course, that's what we're doing today. Exactly, we're taking a look to see if there's an error. So what happened here? Betts was a police officer, was called to a home where there was, he just was called to the home with other officers. Stuff was going on. And at one point, he felt he was facing a deadly force threat, and he pulled a service pistol and he fired a round. And that round struck a solid object, I believe the floor, fragmented, and pieces of fragments struck a small girl nearby in the room. And the state charged the police officer with a reckless use of force, a reckless assault, basically based on the injury caused to the little girl. And the officer said, well, wait a minute. I fired that law in self-defense. I fired that round, in self-defense. And Kansas has a self-defense immunity statute. So the officer saying, Officer Betts says, I fired that round that caused the injury to the girl in self-defense. Kansas has a self-defense immunity statute that immunizes me from legal liability for a use of force in self-defense. Therefore, I want these charges dismissed summarily under the immunity statute. And I believe the trial court did dismiss the charges. The state appealed this to the appellate courts, I believe, who affirmed it. And then it got to the state Supreme Court. And the state Supreme Court said, no, we're going to reverse this summary dismissal of the charges, send this back to the trial court. So it's that dismissal, it's that reversal of the dismissal by the state Supreme Court that Jared is suggesting is inconsistent with how I describe injury to innocent bystanders. As I imagine what Jared's thinking is, Andrew says there is no liability for injury to bystanders when you act in self-defense. And here the Kansas Supreme Court is saying, no, this officer can be held liable for injury to an innocent bystander when he acted in self-defense. The trouble, Jared, is that the devil is in the details. And frankly, I don't think the Kansas Supreme Court even goes far enough in denying this officer immunity. We'll dig into that in just a moment. But let's take a look at this case. And I guess I do have to make it bigger and make me smaller so we can actually see it. Let me see. Maybe I can do this instead. My post-production guys don't like it when I make myself that small. All right, State v. Betts, Kansas, Supreme Court, 2022. Let's see. Here's the opinion of the court. So this is case law. This is appellate court case law. And they're going to provide a background of the facts here. While securing the interior of a family home during a domestic violence investigation, Wichita police officer Dexter Betts fired 2 gunshots in quick succession at a fast approaching dog he thought was attacking him. He missed, and bullet fragments struck a young girl sitting nearby. The state charged the officer with reckless aggravated battery for injuring her. Betts moved to dismiss the charge before trial. He argued state law immunizes his use of deadly force in self-defense, even if he acted recklessly and regardless of who got hurt. The district court, meaning the trial court, agreed and dismissed the case. When the state appealed, a court of appeals panel affirmed, agreed with the dismissal. On review, the Kansas Supreme Court says, we reverse the grant of statutory immunity and remand the case to the district court, the trial court, for further proceedings. Hopefully, in this first paragraph, all of you already see what the problem is here. The problem is the claim that the officer's conduct was reckless. Now, the Kansas Supreme Court is not saying that his conduct was reckless. They're not making a finding of fact here. What they're saying is that it's possible it was reckless. The argument is being made. And that's a finding for a finder of fact to make, a jury to make at trial. And if it was reckless, if a jury were to decide this conduct was reckless, then it was not a lawful use of force. And if it was not a lawful use of force, it was not lawful self-defense. And if it was not lawful self-defense, you can't qualify for self-defense immunity. And if you don't qualify for immunity, the charge can't be dismissed on the grounds of immunity. So the core defect to Betts' claim here is nothing to do with the doctrine of transferred intent. If the jury determines that his use of deadly force was lawful self-defense, then transferred intent would relieve him of liability, independent of the immunity statute, for the reasons I already discussed. But if the use of force was reckless, then neither transferred intent the doctrine of transferred intent, which doesn't apply to reckless conduct, nor self-defense immunity, which also doesn't apply to reckless conduct, can save this officer from the reckless battery charge. All right. Let's continue with the state court opinion here. The appeal presents facts we have not considered before. So this fact scenario has not before been in front of the Kansas Supreme Court. In the typical self-defense immunity case, the state charges a defendant with an intentional crime committed against a person claimed to be the aggressor. And when the defendant invokes statutory immunity from prosecution in the case involving the use of deadly force against the alleged aggressor, we determine whether the defendant had a reasonable belief such force was necessary to prevent imminent death or great bodily harm to the defendant or a third person. But what about a circumstance like this, when the crime charged involves an innocent bystander who was unintentionally injured during the defendant's allegedly reckless conduct while engaging in self-defense? Continue here. We hold that the Kansas self-defense immunity statute does not extend its immunity to a defendant's reckless acts while engaged in self-defense that resulted in unintended injury to an innocent bystander as alleged here. Then they have a statement of the facts, which I've already basically covered. The state's case alleges Betts consciously disregarded a substantial and unjustified risk of injury by firing his handgun twice at the dog while the girl sat nearby on the living room floor. And that's the definition of recklessness, right? The conscious disregard of a known risk, substantial and unjustified risk of death or serious bodily injury to another person. That's what Alec Baldwin did, right? When he shot Helena Hutchins with a gun he did not ensure was unloaded. but pointed at her when he fired the gun. And of course, reckless conduct is not lawful, not justified, not a foundation for transferred intent, which requires a lawful underlying intent. So just the fact that it could be recklessness would mean now we have a fact issue that needs to be determined by a jury. And if they find recklessness, there is no transferred intent, there is no self-defense immunity. I would suggest, in fact, that there is no self-defense immunity here under any circumstances, even if the shooting was not reckless. Because I would suggest that self-defense immunity under Kansas law does not apply to a circumstance in which you're defending yourself against a dog. Because defending yourself against a dog is not self-defense in the context of the legal justification of self-defense. Of course, the physical act is one of self-defense. You're defending yourself against some threat. But the statutes, the legal justification of self-defense is intended to cover situations in which you're justifying your use of force against another person. Not when you're trying to justify your use of force against an animal. So physically, you're defending yourself against both the person and the animal, but the legal justifications are different. Defending yourself against a person would fall within the scope of the justification of self-defense. And the 5 elements of self-defense, which we talk about all the time. If you're defending yourself against an animal and it's claimed that use of force was unlawful, your justification argument is a different one. It's the justification or the excuse of the doctrine of lesser harms. The doctrine of lesser harms holds that, and some variation, it's called different things in different states, but some variation of this exists in all states. And the doctrine is that, yes, I committed some small, relatively small, illegal act, but I did it to avoid some much greater harm. And the classic illustration would be, it's a hot day in the summer and you walk by a car and you notice there's a baby strapped in a car seat, locked in the car. And it's hot enough that you have a reasonable expectation that baby's going to suffer death or serious bodily injury if it's not freed from the vehicle. The car doors are locked, so you break a window of the car to unlock it and save the baby inside from death. Is it unlawful under normal circumstances to break someone's car window? Sure. But if you were charged with a property crime in that context, your argument would be the doctrine of lesser harms, or sometimes called choice of evils. Yes, I committed some small harm, relatively speaking, by breaking the window of the car. That's not mine, but I did it to avoid some much greater harm. And that makes the conduct legally excusable. So no legal or civil liability. That's the argument you make when you're using force against an animal attack. You can't just go around shooting dogs. But if the dog's attacking you, you would say, listen, I engaged in something that would normally be unlawful conduct, shooting the dog, but I did it to avoid some much greater harm. The dog maiming me, injuring me. Humans are more valuable than dogs. I know some of you will disagree, but that's how the law sees it. So if we look at the Kansas immunity statute like we have here, it basically says a person who uses force that is justified pursuant to Kansas statute 5222, 223, or 225 is immune from criminal prosecution. So I'm not going to read the whole immunity statute, but right up front, we know to qualify for immunity, your use of force has to fall within the scope of 5222, 5223, or 5225. If it doesn't, there is no immunity on the table for you to claim. Well, what does 5222 say? That's Kansas core self-defense statute. And it says the person is justified. A person is justified in the use of force against another person, when and to the extent it appears that such person reasonably believes that such use of force is necessary to defend against the aggressor. And a person is justified in using deadly force under those circumstances if they believe it's necessary, but those circumstances are against another person, not a dog. So defending yourself against a dog attack doesn't fall within the scope of 5222. It would fall under that doctrine of lesser harms or the doctrine of choice of evils or the doctrine of necessity, whatever Kansas describes the doctrine I just shared with you. Well, what about 223? Well, this is a defense of dwelling, place of work, or occupied vehicle statute. The officer wasn't doing any of these things, so he doesn't qualify for 223. What about 225? Well, that's defense of property other than a dwelling, so just personal property. Well, the officer wasn't doing that either. So he doesn't fall within the scope of defense of personal property here. He doesn't fall within the scope of defense of dwelling. He wasn't defending a dwelling against another person. And he doesn't fall within the scope of self-defense because he wasn't defending himself against another person. So if he doesn't fall within the scope of any of those, then he doesn't fall within the scope of the immunity statute, period. So I don't think this officer has a self-defense immunity argument to make at all. That should have been dismissed at the trial level. He does have the transferred intent argument to make, but then he has to be able to overcome the claim that his underlying intent was one of recklessness. So that's where we are with all of that. All right, I'm going to quickly turn to see what questions we have from our members. By the way, we only ever answer questions from our members on the Law of Self-Defense member dashboard. I'm taking a look at that now. So you might consider becoming a Law of Self-Defense member. You can become a member for just 99 cents, 2-week trial membership. Gets you access to our member live streams on the member dashboard, where we have the member chat, where you can post your questions and comments that I will address. lawofselfdefense.com/trial for that 2-week trial for 99 cents. And if you stay a member, it's still dirt cheap, folks. It's only about 30 cents a day, less than $10 a month, 30 cents a day to be a Law of Self-Defense member. So I would encourage you to consider that at lawofselfdefense.com/trial. Member asks, unrelated to today's show, I just started our level 1 core class. That's our full day class. And I'm wondering whether self-defense presumptions are valid when staying in a family member's or friend's home. You just have to look at the precise wording of the statute. If it says you're defending yourself in a dwelling, then it wouldn't matter whose dwelling you're in. If it says your dwelling, then it would matter. Let's see. Adam says, Law Self-Defense member Adam says, my firearms instructor brought up the example of shooting at someone, attacking you, and accidentally shooting a baby. Would any jury still apply transference of self-defense or transfer intent? Well, I can only tell you what the law is. I can't tell you what a jury is going to do. If a jury is going to have an emotional response and not obey the jury instructions they receive, that's always possible. That's why innocent people get convicted. That's why there's never merely a 0 chance of conviction. Innocent people get convicted all the time. I can only tell you what the legal arguments are. And then, if you're a Law of Self-Defense Platinum member, I can help your lawyer craft the legal argument to be as compelling as possible. Rick, Law of Self-Defense member Rick asks, seeing a dog as property is viewed by the courts, if the owner is directing or allowing the dog to attack you, is this situation no different than the owner using a bat, knife, or gun? Yeah, if the owner has an attack dog or is using the dog as a tool to attack you, it's no different than the owner using any other weapon to attack you. If you reasonably believed you could stop the dog attack by shooting the owner, you would be privileged to shoot the owner to save yourself from what's presumptively deadly force attack by the dog. I don't know how you would know that, though. I mean, frankly, I'd be more inclined to shoot the dog, I think. But dogs are hard to hit, right? This officer fired twice and missed. Dogs are small, they're fast, they're low. But yeah, if the owner's using the dog as a weapon, conceptually, it's no different than the owner using anything else as a weapon. All right, cool. It looks like those are all the questions. And I am in a bit of a rush today, folks. So I just wanted to knock this one out. Thanks again to CCW Safe for making their office facilities available to me to do today's show under these rushed conditions. They had no idea I was even going to be in town until a couple of days ago. So it was very kind of them to accommodate me. And remember, CCW Safe is the only self-defense legal coverage organization that I trust. For myself, I'm a member of CCW Safe. My wife, Emily, is a member of CCW Safe. I encourage you to learn why I feel that way. I have good reasons for it. I'm happy to explain them to you. And I'm so happy to do that I recorded a little video explaining it. You can find that at lawofselfdefense.com/trust. Lawofselfdefense.com/trust. All right, folks, with that out of the way, I will remind all of you that if you carry a gun, so you're hard to kill, if you carry a knife, so you're hard to kill, if you carry pepper spray, so you're hard to kill, if you study jujitsu, so you're hard to kill, I do all those things, so that I'm hard to kill and my family is hard to kill. Well, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.